the second and third witnesses of the petitioner. What happened in the strong room, the allegations of irregularity are clearly before this court. So it cannot be fresh evidence. Secondly,
it's not asking for fresh evidence. Please look critically at the motion.
He's seeking to reopen the case.
That's right.
So that he can subpoena. My Lord, and that is why, my Lord, with all due respect, that is why I think that the substance of this, or the content of what he intends to achieve through the subpoena must be assessed, evaluated by this honorable court before it can decide whether or not to exercise its discretion in granting the application to reopen.
Yeah, I think, Mr. Jesse, we heard him. Sorry, Mr. Kutampa.
My lords, my good friend, Mr. Chachichikata referred to me as my friend Sheshe in the course of these proceedings.
You see, I think he made a point that they want to reopen their case so that they can serve subpoena on the on Mrs. Jane Mensah, so that she can be treated as a hostile witness. Yes. So address that, please.
My lords.
Mr. Kutampa, whilst you're addressing it, I also understood from him that you did some harm in cross-examination. You brought certain things out in cross-examination. So he should be allowed to speak to that through the process of the subpoena.
Yes. My Lord, our case is that at the time he was electing to close his case, he knew, the petitioner knew these new matters that were elicited from his witnesses were matters of record. And if he really intended to do that, he should have applied to the court to enable him to lead, to file a new witness statement, to leave evidence on that. He didn't do so. He had all the information at that time, and he boldly declared to the court that he was closing his case. The only reason why now the petitioner is applying to reopen his case is because after he closed his case, the respondents exercised a right that they had not to adduce any evidence. And my lords, counsel for the petitioner and the petitioner cannot say that they did not have an inkling of an idea that this was a possible approach that the respondents would adopt. First, because it is a process that is available in any trial for defendants.
Second, Mr. Kutampa, look at paragraph 16 of the affidavit in support. They said they were taken by surprise.
Yes.
By that year.
Yes.
It therefore came as a surprise.
Yes.
That both counsel for the respondent announced on Monday, 8 February 2021, that this was no longer the case. This was no longer the case. Paragraph 16 of the affidavit in support. Which means they had prepared to cross-examine your witnesses. And that was why they closed their case.
Yes.
They had no inkling whatsoever that you were going to close your case.
Yes.
And then this matter came to them as a surprise.
Yes. My lords, if I may respond to that. My first point is that if they had thought through fully the case of the respondents, they would have known that this was very likely to happen. Because right from the beginning of our filing our answers, we had served notice to them and the court, but we didn't think that we had any case at all for us to be even heard. And yet, this honorable court, in its own wisdom, directed that you would deal with our preliminary objection at the end of the trial. So they must have had notice that it was likely, if they failed to lead sufficient evidence, that we will not adduce any evidence. And consistent with our original and primary position, we would ask the court to determine the matter on the evidence before it. So, it is, I cannot believe that my learned friend, Zeta would not have anticipated this matter as a matter of strategy. He should have, and if he didn't, well, my lords, that would be too bad for his client.
Mr. Kotankwa, if I recall, your submissions are already on file, aren't they? Your preliminary objections?
Yes.
They're already on record?
Yes.
Everybody's?
Yes, they've been served. Now, my lords, so that deals with the surprise. And my lords, again, it cannot be the case that they were relying on the statement made by chairperson of first respondent that even if the interrogatories fail, they would have an opportunity during cross-examination. My lord, that cannot be, as I've earlier stated, cannot be a commitment to the fact that we shall lead evidence to the chief. It is only a legal argument that you may have that opportunity during cross-examination. And that opportunity will arise only if you enter the box to lead evidence in chief. So it can never constitute a fact under section, is it 25, 24 of the Evidence Act, upon which they acted to their detriment, and therefore we are estopped, or the first respondent is estopped from exercising his right not to adduce evidence. It cannot be. And my lord, what is even more interesting is that those provisions of the Evidence Act, my lord, we see that section 24 that he reads says that conclusive, 24(2) reads, conclusive presumption include but are not limited to those provided in section 25 to 29. And my lords, if one goes to 25(1), it says, except as otherwise provided by law, including a rule of equity, the facts recited in a written document are conclusively presumed. Again, in 26, except as otherwise provided.
That's on 24 and 20. 25 deals with the contracts and conveyance. And
yes, but my lord, I'm saying that we will see these provisions must be read as a whole. You cannot take this out, because section 26 again repeats the except as provided by law, including real evidence. When a party has by his own statement, act, or omission, intentionally or deliberately, caused or permitted another party to believe a thing to be true, and to act upon such belief, the truth of that thing shall be conclusively presumed. So there are exceptions in law and in equity. So it is not, and the same goes for section 27, 28, and 29. So, my lords, I think that it is misconceived for counsel for the petitioner to suggest that the conclusive nature of the alleged statement of fact by first respondent is not limited in any way. And it is, in our view, limited by the right of the respondents to elect not to adduce evidence. My lords, again, we wish to refer your lordships to the case of the President of the Methodist Church of Ghana versus K spelled K-Y-E, K-A-Y-E. Now, the President of the Methodist Church of Ghana versus K. My Lord, it's a judgment of the High Court, Cape Coast, by Owusu J, as it then was, delivered on 10th April 1970. It's a one-page ruling, my Lord. 10th April 1970.
Is it in the 1970 current cases?
My Lord, it's actually in the law reports 1970, but we couldn't.
1970.
Yes, but we have
the current cases.
Yes.
Yeah.
Yes.
Okay.
So, my Lord,
what did the judge say?
Held. Once a party closes his case, he abandons every right to call further evidence, except with the leave of the court. Precisely, that's why I'm saying that this is an attempt to call further evidence. That is the point I'm making, my lords. You know, and he must be held to the rule or the conditions to be met in order to adduce fresh evidence or further evidence, to use his words. Such an application is only considered when at the time of closing the case, no human ingenuity could foresee the existence of the particular evidence the party is seeking to adduce. That cannot be the case in this situation, my lords. Again, my lords, we also rely on Annabelle and Obosu and another, referred to by counsel for first respondents. And again, my lords, refer your lordships to the case of Combat versus Lambin, 1989. Sorry, my lords. Combat spelled K-O-M-B-A-T versus Lambin, L-A-M-B-I-M, 1989, 91 Ghana Law Reports, 324, where Benny J, as it then was, at the close of plaintiff's case, called a witness Somoto, who testified. No, where the trial court.
Was it the Benny J who called?
No, the trial court. The trial court.
I think this was his similar.
Yes. It was a trial court. Yes. After the case of the plaintiff, close of plaintiff's case, the trial court called a witness, Somoto, who testified in support of the defendant. And based on that testimony, the case of the plaintiff was thrown out. The plaintiff appealed against the decision of the court. The High Court, quorum Benny J. Asidem, was allowing the appeal, stated as follows. The general rule of evidence was that after a prisoner's case was closed, a judge should only call a fresh witness when a new matter had arisen ex improviso, which would not have been foreseen. Such a witness could, in civil cases, only be called with the consent of all the parties. My Lord, let me emphasize, with the consent of all the parties in civil case. My Lords, we believe that the authorities in Canada, Commonwealth jurisdiction, common law jurisdiction, may, with respect, assist your lordships. And we wish to refer to the case of Ontario Limited versus Sagas Industries, Canada Incorporated. It's a 2001 SCC 59 or 2 SCR 98. That's the Supreme Court of Canada. There, the High Court approved of the two-stage test first articulated in the case of Scott versus Cook, 1970, OJ number 1487. Namely, the test which is intended to assist the trial judge in exercising his or her discretion to reopen the trial requires the moving party, one, to show that the evidence he or she seeks to adduce is such that if it had been presented at trial, would probably have changed the results. And two, prove that such evidence could not have been obtained by reasonable diligence before the trial court. Now, these are the same principles that this honorable court applies in adducing fresh evidence. Now, my Lord, it is our submission that this case is about votes and numbers. My Lord, there is nothing about the engagement between the second and third witnesses of the petitioner, alleged engagement with the chairperson of first respondent. Even if true, that has been shown to have had any material effect on the outcome of the elections. And we demonstrated that quite thoroughly during our cross-examination of Mr. Asiedin Ketia, where we took him through all the different stages to show that no matter what you do, first, second respondent cross the 50+ threshold, and petitioner persistently remained around 47%. So, and truth be told, the third witness actually declared during cross-examination why they were going to see the petitioner. What was it? They were going to tell him about the irregularities and errors in the collation process. And the question is, does their claim of irregularities and errors in the collation process legally stop the EC and the returning officer of the presidential election from exercising her independent function and duty to declare election results if, in her view, the election results were accurate? The only thing that the petitioner could do would be to come to court to demonstrate that the election results were not accurate. So, my lords, one cannot fault the EC chair until you come to court and are able to show that the election results were not accurate. And
please address us on the general principles which you've based your submission on the authorities.
Yes.
The EC on record is not your client.
My Lord, I'm a bit taken aback.
Reopening the case may have serious consequences on the case, because both of you may do so many things. But for the time being,
Yes.
the application is for the reopening of the case for the petitioner.
Yes, and
your attention has been so much on the first respondent. And I'm saying that on record, they are not even saying that when the case is reopened, they will subpoena the second respondent to mount the witness box.
That's exactly what they said.
So we want you to address us on why the reopening should.
Very well.
Yes, I think you have to understand the bench.
Very well.
Yes, because they are not asking for anything from the second respondent.
Very well. My lords, my simple submission is that to reopen, they must satisfy the two preconditions. One, that the evidence they intend to lead was not available to them at the time they closed their case and could not have been obtained by the exercise of due diligence. Yes. And two, that the evidence they intend to adduce, if they are given leave to reopen their case, will have a material effect on the case. And we are saying that there's no way that it will have a material effect on the case, given the evidence before the court. Even if they use her as a voter witness. Even if they choose to use her as a hostile witness, my lords. My lords, we also wish to refer your lordships to the oft-quoted case of Dombo and others versus NA, 1970 CC 68, a Court of Appeal case. And then,
that's fresh evidence on appeal.
Yes.
Yes, and please note
an
appeal. Please note, so the principles are never the same. Adduction of fresh evidence on appeal has nothing to do with reopening of a substantive case at the trial court. Yes, or to reopen and
my lord,
please.
My lord, the principles apply in pari materia. That is my submission.
Not all.
No, the principles apply in pari materia. And my lords, '68, a Court of Appeal decision. And my lords, again, in Poku versus Poku, 2007-2008, 1996, Supreme Court of Ghana Law Report, 1996, 996, sorry. Now, my lords, it's our case that the decision of the court in Poku and Poku, even though referred to adducing fresh evidence on appeal, are the same in the case where a party closes his case and applies to reopen his case to adduce further evidence. They apply pari materia. And in that case, would CJ observe as follows at page 1015. Consequently, the invariable rule, as I understand it, is that in an application to lead fresh evidence or new evidence, the first criteria which an applicant ought to establish is whether or not the evidence sought to be adduced was not in the possession of the applicant party, or was not obtainable by the exercise of reasonable diligence or human ingenuity before the impugned decision was rendered. It is only when this first hurdle has been surmounted that the court should proceed to determine the other pertinent question of whether or not the intended evidence would have a positive effect on the outcome. Stated differently, if the first criterion is not met, no useful purpose will be served by examining the other factors. And my lords, it is our submission in respect, if I may make submissions on the question of subpoena, or it is not a matter before your lordship. My lords, it is our submission that the application of the 65 Rule 4 of the High Court rules, CI 47, states, Order 35, Rule 4. Yes, Rule 4. States thus, a writ of subpoena ad testificandum, or writ of subpoena duces tecum, to compel the attendance of a witness for the purpose of proceeding in chambers will be issued out of the registry if the party who desires the attendance of the witness produces a note from the judge or register authorizing the issue of the writ. Further, Section 88(1) of the Evidence Act 1975, NRCD 323, provides inter alia that, except as otherwise provided in this part of, yes, of Evidence Act 1975, states inter alia thus, except as otherwise provided in this part or in any other enactment, no person has a privilege to refuse when duly subpoenaed to be a witness. Now, my lords, the petitioner applied to this court to open his case and to issue a subpoena to compel the chairperson of first respondent to testify. My lords, this should be viewed, this application should be viewed in the peculiar circumstances that first respondent has already elected not to adduce any evidence in this petition. And the court has affirmed its right not to elect or to adduce any evidence. My lords, the process of cross-examination involves adducing evidence. And so, my lords, it's our submission that the object of this application to reopen the case is precisely the object of their opposition to the respondent's election not to adduce evidence. And it is our respectful submission that the court, having upheld that right of the first respondent and the respondents generally to elect not to adduce evidence, cannot with one hand affirm that right and with the other hand disaffirm it by allowing the petitioner to subpoena him, to cross-examine him, and thereby adduce evidence from her. I think that would be inconsistent with the court's own ruling. My Lord,
Mr. Abutuampa, based on the submissions you've just made, what would be your comment on paragraph 15 of petitioner's affidavit in support?
Yes, paragraph 15, my Lord. Yes, my Lord, it's saying that it has become necessary. My Lord, we say that they have demonstrated absolutely no necessity. My Lord, the petitioner has demonstrated no necessity. Because, with all due respect, they have not shown how the grant of the application would have a material effect. That's the necessity. Material effect on the outcome of the matter in dispute. They have not shown it. All that they have said is that the EC has a constitutional role. It has to be accountable. The chair of the EC has to be accountable to the people, so on. And your Lordship, in their ruling, said that the rules that apply to ordinary people in these circumstances equally apply to the EC chair. That's what your Lordship's ruling a few days ago stated. So, my lords, we do not see that they have demonstrated any necessity. All the necessity is based on the fact, the allegation that the chair of the first respondent is stopped from saying that he will not enter the box because she had already committed herself so to do, when the chair of the second respondent never ever committed herself to that and cannot thereby be stopped. My lords, we would with respect end with we will end with the two other cases. My lords, the first is the Northern Ireland case of Ryan Andrew Fulton and Ms. Fulton and Cyril Fulton. Sorry, Ryan, R-Y-A-N, Andrew, and Fulton, F-U-L-T-O-N, and Ms. Fulton and Cyril Fulton versus AIB Group UK PLC 2017 NICA 42 or 2017 WL 03382220.
WLR or WL?
No, that's just WL. L, that's all. Zero. At page 5.
He says 0, the citation.
The citation is, the first one is NICA 44.
Oh, okay.
Yes, 44. My lords, this was a case where in the court below, the High Court judge refused an application for discovery because it did not satisfy the two important tests of disclosure, which are necessity and relevance. And my lords, in your ruling on discovery, you upheld these two cardinal principles, necessity and relevance. My lord, the applicant's appeal was accompanied in the case by an application for subpoena against various people, including counsel for the respondents, to produce discoverable documents. The court, per Gillian LJ, dismissed the appeal and disallowed the subpoena application, stating emphatically in its judgment thus: suffice to say that we are satisfied that the application in front of McBride J for discovery was correctly decided by her, and we affirm her decision. And this, my lords, is the important statement of the law. Accordingly, we also come to the conclusion that there is no basis for the subpoenas now being sought, as they arise out of the claim for disclosure. If discovery is not appropriate, then subpoenas are not appropriate. Lord,
Mr. Akoto, what's the relevance of this case to the present application? You are now dealing with subpoena and discovery. Lord, we've gone past that. We are now dealing with an application invoking our inherent jurisdiction to reopen the case.
Yes. But the reopening, my lords, relate to the substantive issue of the matters they sought to elicit.
As at length on the reopening. But my brother is just asking you how that case bears any affinity.
No, because, my lord, there's a principle that a request for subpoena cannot be used to disguise an application for discovery. That's the principle of law.
No, come again.
A request for subpoena cannot be used to disguise an application for discovery of documents.
No, but we've gone beyond discovery, and these are earlier interlocutory applications which we disposed of several weeks back.
Our understanding of this process in the circumstances of this trial is that they are seeking by their subpoena to elicit the very information that they failed to elicit in their application for discovery. And I'm saying that the principle is that what you cannot get by discovery, you cannot use a subpoena to get. That is the point, my lord. And my lord,
according to you, or according to them, their submission, you give them the promise that you don't need the discoveries. You don't need the discoveries because you'll be available to testify, and they can ask those questions when you are in the witness box.
My lord, with all due respect, we never made any promise. We just stated the position of the law that a matter that you may not obtain through discovery, you may elicit through cross-examination. That is all. We're not saying that we are promised to enter the box, because the time had not arisen for us to adduce
Mr.
elect.
You did not make that promise. Yes, we on record, it is there. But yes. Because,
my Lord.
And more so, you are not appearing for the first.
Yes, my Lord. Yes, that is true. Yeah. But
is it free legal advice?
No, my Lord.
Are you going to be paid?
I'm a party to this case, and as counsel, I have a duty to this court to draw its attention to the correct position of the law. Yes. So it doesn't. I think that it doesn't matter too much that I am not counsel for first respondent. Yes. So, my lords, the last case, my lords, I wish to refer your lordships back again to the instructive words of Wood C.J. in Poku and Poku at page 998. The learned Chief Justice then admonished with great emphasis that, quote, an application to adduce fresh evidence is clearly circumscribed and only operates within its statutory limits. This rule is therefore intended to assist an applicant who has made a genuine attempt to look for evidence and has met with failure. Courts ought therefore to be adept at unmasking attempts by dissatisfied party coming through the back door and under the cloak of having come by new or fresh evidence, seek to fill in the gaps or lapses in his or her case. For the rule is not meant to aid the slothful or the indolent, the careless, negligent, or reckless litigant, whether acting pro se or through counsel. The application is not granted on compassionate grounds. Why is it that the EC, God, and so on should not go into the box? Those are not the grounds. My Lord, neither is it meant to give slovenly, particularly a litigant acting through counsel and who fails at the trial to marshal his facts carefully and fails to conduct his case properly by presenting essential evidence at the trial or through the necessary cross-examination, or also fails to conduct the necessary investigation which would have thrown light on the strengthen his case, a second chance at rebuilding his or her case. Under such circumstances, an unsuccessful attempt to lead fresh evidence cannot be met with the criticism that the court was visiting the iniquities of counsel on the client. Either for the law has made provision for redress where the loss of a suit is the direct result of recklessness or negligence of counsel. And it closes. A party who goes to court has the sole burden, and let me emphasize, the sole burden of leading sufficient evidence to prove his case. He cannot rely on the weaknesses of his opponent or rely on his opponent in prosecuting his case. And it is for this reason that Sarkodie, Iberima, Jamfi, and another versus Beidou, 1963, 2 Ghana Law Reports, 596. The Supreme Court, Coram Sarkodie Ado, Olenu, and Blade JJSC, speaking through Olenu JSC, Ozel, at page 597 as follows. The plaintiff could not have called any of the other eyewitnesses because they were the very people against whom he was litigating his title. And it would be nothing but madness for a party to assume to rely on his opponents to prove his case. My lords, we rest our case.
Mr. Akutampa, I think you have to change your wig. It has lost its identity as a will.
My Lord, it gives it unique identity.
My Lord, may I, with your leave, just make one short point in response as a matter of law. And my Lord, I just wish to point out that we could not, at the time we closed our case as a matter of law, we could not have subpoenaed Mrs. Jean Mensah because she had a witness statement that she had filed in this court on behalf of the first respondent. That witness statement was in this court in addition to the affidavit that I referred to. So at that point in time, we could not have subpoenaed her.
Mr. Chikata, just one, flowing from the submission from counsel, in these proceedings, this court has upheld the right of the chairperson or the first respondent not to testify.
No, my Lord.
No, by our ruling, let me land. We have confirmed her right to decide not to testify. So don't you think that there's a judicial bar as far as this proceedings is concerned?
My Lord, no.
For her not to testify?
No, my Lord, no. What your lordships ruled on was the right of the first respondent not to adduce evidence.
Yes. He is representing the first respondent.
No, my Lord, respectfully, the returning officer of the election is an individual. The first respondent is the commission. Now, and that is why, respectfully, I made the point that as a matter of law, at the point in time when we closed our case, we could not have subpoenaed her because at that point in time, she had put in a witness statement on behalf of the first respondent. So the only point at which the matter changed, which necessitated, that's the necessity in paragraph 15 that we're talking about. The point in time at which that situation changed was when it was indicated that despite the earlier election to adduce evidence, there would no longer be evidence adduced by the first.
My lords, with all due respect, this court has ruled that the first respondent never elected. So counsel cannot be speaking to the same court and suggesting that she elected. We have to be faithful to the record of the court. My Lord, the public is also listening, and they can be misled.
You see, the point I'm making is that in our ruling, we specifically said that the chairperson of the first respondent has a right not to adduce evidence. And so
not to adduce evidence. That's what your lordship just said.
Yes.
In other words, I mean, you were speaking about the first respondent as first respondent. That's the electoral commission.
No, the chairperson. Also specific. The chairperson. Not the first respondent. In fact, she put in the witness statement, as you have been referring to.
Yes.
And those affidavits were deposed by her. And so we said that specifically the chairperson or the first respondent cannot be compelled to adduce evidence. So don't you think that there's a judicial bar? And for that matter,
there's a judicial bar. There's a judicial bar.
And for that matter, she cannot be compelled through any other means to testify in this proceeding, so long as these proceedings are pending.
My Lord, no. My Lord, of course. I mean, you know, we have every right to seek a review of that ruling if the interpretation that you're giving, if the interpretation of that ruling that you're giving is right. But the point that I wish to emphasize is that our understanding of the ruling, especially in the context of the orders, the 38, CI 87 issues. In that context, our understanding of that ruling relates to the fact that the first respondent has it within their rights not to call a witness. I mean, just all the authorities that your lordship cited in the ruling were about the right of a party not to call a witness. That's nothing more. That's what the authorities that were cited were about. So a party...
Respectfully, the last but one page.
I'm sorry?
The last, I don't know whether you have a copy of the ruling. It is annexed to the affidavit of the second respondent. Yes. Unfortunately, they did not indicate the page, but it appears the last but one page.
The affidavit of the second respondent.
No, the ruling is annexed.
Yes.
Yeah, it's annexed to the. Yeah. Mm-hmm.
Yes.
Yeah. I think the last paragraph, beginning with, the law is therefore settled that a party will not be compelled to enter the witness box and testify in support of
a party. The chairperson is not a party.
Parties who decline to give evidence take, knowing perfectly well that the court will be left with no option but to proceed with the available evidence before it. Counsel for the petitioner has strongly submitted to us that we should not apply the Society of Lawyers case to the peculiar facts of this petition, because the first respondent, being a constitutional body with defined responsibilities, must be brought before this court to be cross-examined as a way of accounting to the people of this country for its stewardship. The Society of Lawyers case, like this petition, also deals with witnesses who had served witness statements and have decided not to give evidence to be cross-examined. Indeed, the witness statement was served by Mrs. G. Mensah.
Yes, but my lords, a party, your lordship just read a ruling in which your lordship referred to a party. The party in this case is the first respondent, not Mrs. G. Mensah.
Yeah,
and we are saying...
Office?
Under the circumstances, who declared the results from the Electoral Commission?
My lords, that is a perfectly legitimate legal separation. The EC is a corporate body, and the returning officer is an individual who happens to be the chairperson of that corporate body. You cannot, with respect, you cannot make the two identical. My lords, otherwise, why would the Constitution make the returning officer the chairperson, not the whole EC? The Constitution is quite clear in separating the role of...
We appreciate that, but then it is the commissioner who declared the result.
The chairperson, in her distinct capacity as chairperson, not the EC. So, my lord, all I was just responding to the point about, lack of due diligence and so on and so forth, and I was just pointing out that at the point in time when we closed our case, there was a witness statement signed by the first respondent. That is our submission. That witness statement, yes, that's all I wish to.
by court. This petition is hereby adjourned to tomorrow. That is Tuesday, the 16th of February, 2021, at 10 o'clock. Please, it's 10 o'clock a.m.
My lords, with all due respect, I have a little prayer to make. My lords, this court directed us last week that we should all file our written closing arguments.
The order stands.
If your lordship will hear me out, if you, by Wednesday, simultaneously, my lords, we have seen a situation where the court has ordered parties to file their witness statements by a certain date, and others applied for review and used it not to file, with the effect that we filed our witness statements before they filed. My lords, I just want to pray for an order to the registrar that if we file our witness statement on Wednesday and the other party has not filed closing addresses, and the other party has not filed because of maybe a review, they should not have any sight of our closing address. Yes. My Lord, that's our prayer. I think it's important to give integrity to the order of the court that all parties must file on Wednesday simultaneously.
As your lordships have indicated, this is a court of record. If he wishes to make an application in respect of the order.
Is it by implication that you are not going to file your closing address?
My lord, this is a court of record, so we'll stick to our record.
All rise.
Let me start by that. Now, just to summarize, the National Communications Authority is mandated by Section 2 of the Electronic Communications Act, 2008, Act 775, to regulate the radio spectrum designated or allocated for use by broadcasting organizations and providers of broadcasting services. Upon assumption of office, I informed them to enforce their law. That's all that I did. Currently, there are 625 authorized FM stations in Ghana as at the end of 2020. 625. A total of 452, representing 72%, are in operation, and 173, representing 28%, are not yet in operation. In 2017, following my charge to them to enforce their law across sectors, not just in broadcasting, the NCA conducted an audit exercise, and which indicated that 144 stations had committed several infractions, which necessitated that they be sanctioned. There's a breakdown of who did what, but I'm just giving a summary. At the end of the exercise, 56 FM stations were closed down. 43 of those stations have submitted fresh applications for authorization, out of which 30 have been processed and granted new authorizations to operate. The remaining 13 applications, I'm informed, will be processed within the first quarter of 2021. So by the end of March, the remaining 13 applications would be processed. Mr. Chairman.
Process for what?
Well, there's a procedure. Maybe let me recap. After the FM audit, certain fines were imposed ranging from several millions of cedis to thousands of cedis on some of the affected stations. Some operators started paying those fines. There was a huge outcry that the fines were too much. And so I came to this house and announced that upon consultation with the board, we're taking the decision to reduce the fines. The board itself took further action to reduce the fines to 1 year. Some had been in default for over 16 years, and they had calculated it backwards. Dissatisfied with all that, some of these stations went to court or the tribunal. Now the tribunal decided that the NCA acted wrongfully in imposing fines on those whose authorization had expired and had not applied for renewal. They could only impose fines on those who had valid authorizations. Now, if you do not apply for renewal 3 months at least before your license expires, it means you do not have a valid authorization, and you revert to the position of somebody who is now going to apply for an authorization. And so the NCA had to refund the monies that they had collected from those that they fined. And if the law doesn't allow you to operate without a license, then you do not have the right to operate without a license. And that's what led to the shutdown of the radio stations. So it was by operation of law. And there are several cases that decided that at the tribunal. And I can leave copies of it for the House, if so required.
Chairman, just a follow-up. So you are in the political space, freedom of expression, guaranteed constitutional right, the vehicle to express it is either through our mouth as we do, or through the medium of radio and television, walking the delicate path of a balance, will you consider the closure of FM stations an affront to freedom of expression or a negative to its enhancement in our country?
Absolutely not. To enjoy any right, you come to equity with clean hands. But if the same law which grants you the right to operate as a radio station in furtherance of the freedom of expression, you flout that law as a citizen of this country, you are subject to the laws of this land and the sanctions applicable. And we cannot by any stretch of the imagination say when the law is being applied, it means it's an infringement on the right to free expression.
My question is within the context of your own reference to a judicial decision that those fines, assuming that is what informed a closure, you had done harm to freedom of expression.
The judicial decision was that they did not have the right to impose fines, and they should enforce the law which applies to those who operate without authorization.
So did the imposition of the fines occasion the closure of any FM station?
No. The imposition of a fine did not occasion the closure of any FM station. Those operating without valid authorizations in violation of the law were closed down in implementation, in the enforcement of the law.
Come on. Please, if you may indulge me, follow. So, Honorable Minister Designate, from all that you have said in respect of the radio stations and NCA closure and imposition of fines, strongly you are making a case that you had personally not targeted any particular radio station as no. Very important. Neither had NCA targeted any particular radio station for political reasons. I just would want you to underscore that point from what you've just said.
Mr. Chairman, it is not possible for me to target any particular radio station for special treatment. Many of the names, I had no idea of what the political leanings or ownership of many of these stations are, apart from the known ones. And I believe even the chairman's own station suffered from this exercise, or a station he's affiliated with suffered from this exercise. It couldn't have been selective or discriminatory or unfair. Unfortunately, in enforcing the law, you have no way of knowing where the chips would fall. And so you work to ensure that you do it with a human face. And I believe that's what the NCA was trying to do when it imposed the fines, instead of closing down the stations outright. I'm not sure they opted for one or the other, but they figured that, and many affected persons did. On appeal to me, I directed them to go back to the NCA to sit down and talk to them and see how they could enter into payment terms and arrangements for them to settle these and some did and started paying. Others chose to go to court, which was their right.
So Muntie and Radio Gold were not targets?
Absolutely not. If they hadn't acted in contravention of the law, nobody could have touched them or targeted them, no matter how much you disliked or hated them. You couldn't touch them because they would have been compliant with the law. So I'm grateful for this opportunity to clarify the air on that. Thank you.
Honorable,
Thank you, Mr. Chairman. Honorable nominee, my question goes back to connectivity. There are many communities lacking telephone connectivity in this country. Recently, His Excellency President Mahama was in Turwe in the Savannah region, attending the burial of the late member of the Council of State, Tulewura Mahama. And all attempts to reach him, even in an emergency, proved futile.